Okay, welcome everyone to the our CMC webinar titled Website Litigation Under the ADA, Protect Your Property from Lawsuits. So let's go ahead and get started. For those of you who don't know either of us, we just wanted to briefly introduce ourselves. My name is Jordan Schwartz. I've been a partner in the labor and employment practice here at Conn Maciel Carey since we started in September 2014. And really, the great majority of my practice focuses on these ADA Title III claims. So I deal with both website ADA issues and just more traditional brick and mortar ADA issues, at hotels, resorts, retailers, or any other place of public accommodation, which I will describe what that means in a few minutes. I also do more, traditional employment law, where I deal with ADA in the employment context, as well as Title VII, FLSA, FMLA, conduct investigations on harassment and discrimination, deal with trade secrets violations and things of that nature.
Hi everyone, my name is Megan Shaked. I am an associate in Conn Maciel Carey's San Francisco office. I joined the firm in 2018, and I also handle ADA lawsuits in federal and California state court. As a member of the labor and employment practice, I also handle advice and counsel and litigation on all aspects of the employment relationship. And I'm also a member of our firm's OSHA practice and handle investigations and appeals and with Cal OSHA.
Okay, great. So today's agenda is pretty simple. We're going to focus, on Title III of the ADA. I'll give just a brief background of what Title III is for those of you who don't know. And then the great majority of the conversation will be on website accessibility issues. I will talk about WCAG compliance and what that means, and whether your websites need to be accessible for those who are hard of hearing or who are visually impaired. And then Megan will pick it up and talk about compliance with ADA regulations for your websites. But first, let's just do a real brief overview of Title III of the ADA. As hopefully almost all of you on this webinar know, it's a general civil rights law that requires all places of public accommodations to be accessible to individuals with disabilities. That is with regard to anyone's participation and enjoyment in a place of public accommodation. Typically, over the years, these issues have arisen in buildings, what we refer to as brick and mortar claims. For example, if your property doesn't have an accessible parking stall or doesn't have a sufficient ramp, or the restrooms are not accessible. And there are certain regulations, either the 1991 standards or the 2010 standards, that govern what your brick and mortar requirements are. And for all those, those requirements, since 1992, all places of public accommodations are required to adhere to those requirements. What we're going to talk about today, though, is what do we do about a website, because the 2010 standards and the 1991 standards do not actually discuss websites, and that is the source of all the confusion and continues to be the source of confusion to this very day. Since September of 2010, the Department of Justice, which is the federal agency that enforces Title III of the ADA, has stated that it is or will be issuing new regulations to address website accessibility. That was over 10 years ago now, and we're still waiting. So as of now, those regulations do not exist. And that differs a little bit with the portion that Megan will be talking about, because she's going to be talking about regulations that actually exist. But for my portion of the presentation, it's all about regulations that don't exist. And one other point here that almost every client ends up asking me, this last point here is, well, I have a property and even a website that's related to a property that was built before 1992. Can I be grandfathered out of the ADA? And I just always want to be clear and let you know there is no grandfather clause. Even if your property was built in 1850, you still need to comply with the ADA to the extent it is readily achievable to do so. So if there's one thing I want you to remember, it's if you're in an older property, is not to just assume that the ADA does not apply to you, because that is not correct. I mentioned the word places of public accommodation a few times, and that is going to be very important generally for ADA coverage, but as we delve into this website issue, because places of public accommodation are physical places, at least defined in the regulations, where members of the public can enter, whether it's a store, a hotel, a restaurant, things of that nature. A website, we have never been sure whether a website is a place of public accommodation, because the current regulations just don't address that topic. But what you do need to know is what Title III of the ADA does is prohibits a place of accommodation, such as a hotel or a store, from denying services and accommodations to individuals with disabilities. And it even protects individuals who are associated with individuals with disabilities. And at the end of the day, what Title III does is it gives you, as a business owner or operator, the obligation to remove barriers to access, both physically and potentially website related, as we'll discuss, and to modify your policies, practices, and procedures. Again, even with a website, to make sure individuals with disabilities can participate in the equal enjoyment of the website. So with that being said, let's go right to website accessibility. And there are two issues with website accessibility. The first issue is the one I am handling in the next 20 minutes or so. And the question is, does your website need to be accessible for users with visual, hearing, and physical impairments? And that is unfortunately a complicated answer. Right now, I'm still leaning towards the answer being yes, but it is not a black and white answer. And then the second half of the presentation, Megan is going to discuss whether your website must provide information regarding various accessibility features at your hotel. So that's not technically whether your website is accessible, but whether your website provides relevant information about whether your property is accessible. But that issue does result in claims against the property based on the alleged insufficiency of the website. But for me, I am focusing here on this first issue, website accessibility issues for users with visual and hearing impairments. And this issue comes along when a customer or potential customer with a visual or hearing impairment is unable to navigate your company's website. Typically, a website should be compatible with what's called screen reader software or screen access software. And then the individual, through his own connection on the computer, can hook up the screen reader software to his computer and be able to navigate your company's website. The issue that arises is when that is not possible because your website is, again, not compatible with or does not comport with this certain screen reader software. So the first bullet point here is that tension exists in courts and in the DOJ whether Title III actually applies to websites. Currently, as I think I mentioned, all places of public accommodation listed in Title III in the actual statute are only physical places. And since there is no specific DOJ standard, there's only recommendations. Every law that the law that has developed in this issue is all based on case law. And as you all know, cases arise in different jurisdictions. A judge in California may rule differently than a judge in Florida. And those are the types of things I'm going to talk to you about. And it's through that piecemeal of case law that we need to determine what the law actually is and what your obligations are as a business owner or operator. But at the end of the day, courts have ruled on both sides of the issue. There is no absolute universally recognized standard for achieving website accessibility, although this last bullet point says there are certain guidelines called Web Content Accessibility Guidelines that have been promulgated. The latest one is called version 2.1, and the trend is to comply with those guidelines. And still, the trend is for courts to find that websites are, in fact, places of public accommodation. That being said, there's a recent decision that I'll be discussing in a few minutes that is a very noteworthy decision and one of the first circuit court decisions in a long time to find, to hold that websites are not places of accommodation. So that's kind of thrown the law, you know, into flux a little bit. But what I'll need to do here is just summarize a few cases for you. In other presentations I do, I always try to avoid summarizing cases because it tends to be not as dynamic as some other aspects of presentations. But here, as I mentioned, the whole law, the entirety of website accessibility law is developed through case law. So there's really no other choice but for me to at least just quickly describe these cases. And really the biggest case in this area initially came out in 2017, and it's called Gill versus Winn Dixie. And in that case, the supermarket customer alleged that Winn Dixie's website was incompatible with screen reader software, and thus, you know, he was not able to utilize the website. And the court held, this was the Southern District of Florida, held that a website that is heavily integrated with a physical store location and operates as a gateway to the actual store constitutes a service of public accommodation covered by the ADA. In other words, the court found that unlike, let's say, just a website like Amazon that is only a website, this website, there was a nexus between the website and the actual physical place, the actual Winn Dixie store that you could touch and walk in. And because of that, the court found that the website was a place of public accommodation. The judge declined to rule that a website is always a place of accommodation, but he ruled that it was so in this case. Now, you're just going to have to remember this case for a couple minutes because there's a few other cases I have to go through first, and then we will revisit this case. And the next one is also in 2017, a case in New York that also ruled that websites are places of public accommodation, which people with disabilities have a substantive right to access. And the notable thing about this case is that the judge rejected the approach used in Winn Dixie and wrote that rigid adherence to a physical nexus requirement leaves potholes of discrimination in what would otherwise be a smooth road to integration. So, in other words, he found that any website which offers direct sale of goods or services to the public is on its own a public accommodation. So this judge would have found that Amazon would be a place of public accommodation and that you didn't need to have the physical store location. So again, that kind of shows how the law in different jurisdictions is developing differently. Then we came to a really big case in the Ninth Circuit, which is the West Coast, in 2019, where this case, as with the others, centered on the inability of individual who was visually impaired to use Domino's website to order pizzas online with the use of applicable screen reading software. Initially, the lower court in California dismissed the lawsuit and held that although Title III does apply in some cases to the internet, here, allowing the case to proceed without clear regulations from the DOJ violated Domino's due process rights because they weren't sure what they needed to do. But the Ninth Circuit reversed that decision and held that Title III does, in fact, apply to websites, and that the lack of any official web accessibility regulations does not implicate due process concerns. And then it suggested that the lower court reference those guidelines that I mentioned to you earlier when structuring the actual remedies. Domino's disagreed with that decision and filed cert with the U.S. Supreme Court to hear the case, hoping that the Supreme Court would issue some guidance. I actually have a quote I'll read for you in a second about that. But at that time, the Supreme Court denied to hear the case. So right after that, Domino's expressed disappointment with the Supreme Court's refusal to hear the case, and it's understandable. What Domino's said was creating a nationwide standard would eliminate the tsunami of website accessibility litigation that has been filed by plaintiffs' lawyers exploiting the absence of a standard for their own benefit, and chart a common path for both businesses and nonprofit institutions to follow in meeting the accessibility needs of the disabled community. And you can sense Domino's frustration that and probably with a lot of people on this call, that at this time they just really didn't know what to do. So with a circuit split, they were looking for guidance from the Supreme Court. But again, the Supreme Court declined to issue such guidance. And then that brings us to where we are right now, which is even more confused than we were during the Domino's case, because now we get to the current Gill versus Winn Dixie case. I mentioned the district court ruled in, I believe it was 2017. So now, 4 years later, the 11th Circuit Court of Appeals, and that covers Florida, Georgia, and Alabama, they reversed the district court ruling, and the court specifically found that websites are not places of public accommodation, and that the website in question did not pose an intangible barrier to access goods and services of the store. In support of its position, the court cited to the statutory definition of the term public accommodation. And the court noted that there's an expansive list of 11, or I believe, lists of 11 specific types of physical locations. And that list does not include websites. So the court, reasoned the plain language of the statute is unambiguous. Public accommodations are limited to actual physical stores, and Winn Dixie was not the sole access point, or Winn Dixie's website was not the sole access point to the store. So, in doing so, the 11th Circuit, completely negated this nexus and gateway language I read to you a few minutes ago at least in the 11th Circuit. Yeah, the ironic thing is it was in this court, in the lower court, the Southern District of Florida, that really created this nexus standard. And now all courts throughout the country have relied on that standard, including the Robles versus Domino's case in the Ninth Circuit. That even, relied on that language that now is no longer good law, at least in the 11th Circuit. So, where to go from here? Or let me just point out that this court did try to distinguish that Domino's case. And but essentially it said that it didn't find the reasoning of the Ninth Circuit that persuasive. And the difference was, or one important difference was, in the Ninth Circuit, you could actually order pizza online on the Domino's website, where the Winn Dixie site, you can only look up information, but you can't actually order information. It's at this point, it's really hard to say how much of a difference that is, other than the 11th Circuit is creating a very narrow view of the applicability of the ADA to websites. So as a result, in the 11th Circuit now, a plaintiff will have obstacles to overcome in order to bring an accessibility lawsuit. So for that reason, this decision is a huge victory for business owners. But it really only is a victory if you are in Florida, Georgia, or Alabama. If you're somewhere else, you can certainly try to rely on this case and cite it as persuasive authority. But it is by no means the actual law of the land at this point. So hopefully now with this decision, the Supreme Court really will step in and resolve this circuit split, because this is a very significant split now in terms of whether or not websites need to be accessible. But for me, and Megan, as your, ADA counsel for at least this hour, and for those of you who we work with, on a daily basis, we still need to take the position that you need to make your websites accessible, because right now there's really only, 2 or 3 states that take, based on that new case, that take an alternative position. So it's too risky for me to just say, oh, let's just rely on this Gill versus Winn Dixie case and forget about the accessibility for your website. So that's just not prudent for us to do yet. So let me take a break from case law there for a few minutes now and talk about what are the common website accessibility issues? What do you need to be, cognizant of when you're looking at whether your website is accessible? And the main issues for especially for users with visual impairments come from menus that are in PDF format. If you own a restaurant, or if you're managing a hotel and you provide food menus for spa services, anything that's in PDF format, that's typically not accessible with screen reader software. It can be, I'm not saying it's definitely not, but more often than not, from what I've seen, it isn't originally. You just have to make efforts and go through some processes to make sure your menus are accessible in PDF format. Other difficulties are pictures, symbols, maps, diagrams, and any pictures with no written descriptions, any links that just say click here, text as an image file as opposed to an HTML file. For users with hearing impairments, it's really difficult for them to navigate if there are video and audio files with no captioning. And for users with physical impairments, it's troublesome to navigate a website, without a mouse or a keyboard. So this next slide here is the slide that's in conjunction with the previous slide, is what should you do to resolve those problems? And for the pictures, for the pictures and maps problem, you want to provide text alternatives for content that is non-textual in nature. You also want to provide text captions for content that is only audio. You want to avoid using color as the only means of conveying information, such as only having something that says green means go. You want to make all functionality available from a keyboard interface as opposed to only requiring a mouse clicks for someone who cannot utilize that. And you want to provide a way to pause or slow down some of the timeout features that are on some websites. And what you'll need to do, you can't really tell, you can't test your website really just by looking at it. You'll need to use some certain either ADA consultants, which I will talk about in a minute, and I highly recommend, or some other web accessibility evaluation tools, at least for an initial review of your website. And I provided a few potential tools here that at a minimum, regardless of what these cases say, you want to proactively test your website's accessibility so you know whether or not there are issues you need to be cognizant of. Some of these website accessibility evaluation tools are by no means perfect. And I have ADA consultants tell me all the time, they do not replace actual human beings testing your website. But at the very least, they can give you some sort of estimation of whether or not you have issues. That really should not be, if you do though, using web accessibility tools should not be the only way that you go about fixing your issues. And then you'll need to determine, let's say your website is not accessible. That's when you need to call an ADA attorney and or call an ADA website consultant and figure out some sort of policy and remediation plan. That could include a timeline for remediating your accessibility issues. Can you do it in the next 3 months? Can it be 6 months? Can it be the next year? Who is gonna participate? You really need to get buy-in from the high levels of your organization, or this really probably won't see the light of day. You may want to identify an accessibility project leader. And depending on who you work with and what industry you're in, making third-party vendors and providers aware of the accessibility requirements and expectations. Megan's going to talk a little later about how there are some lawsuits dealing with third-party online reservation systems such as Expedia and Orbitz, but the lawsuits are actually against the hotels. So what the hotels need to do is inform their vendors like Expedia that, hey, these are the accessibility requirements and expectations, and have discussions about that. So that's just something you need to keep in mind. And hopefully you will be able to improve your website and create some sort of web accessibility policy. And I will talk about an accessibility statement in just a minute. And you want to ensure training and compliance with the policies. The people in your IT department, better be on board and know what's going on here. There is a defense, you almost never see it used, but it is possible that if there is a lawsuit, you can claim that you were unable to implement certain accessibility features because they are unduly burdensome or would fundamentally alter your website. But that is a very heavy burden to prove, and it'll probably end up costing a lot of money in discovery to try to prove that defense. So it's really not something I see too often. But at the end of the day, really there's no replacing the retention of ADA website accessibility consultant. That is really, there's different ways you can do it. They can have full control of your website and actually fix it, or they can just consult your IT group and walk them through what they need to do. And, just serve as an advisor. And, that is just really important to make sure that, they're the specialists here, and they're really the only ones that can make sure your website actually is ADA compliant. From a legal perspective, what would be much more, prudent would be to contact your attorney and have your attorney retain the accessibility consultant, even though the attorney need not be involved through the entire remediation process. And you don't have to be paying your attorney thousands and thousands of dollars to be heavily involved with the actual ADA website issues. But if you have your attorney retain the ADA consultant, everything the ADA consultant is doing can be upon the, what's called, quote unquote, upon the advice and direction of counsel. And then that entire process would be privileged, and you would never need to turn it over for discovery. Otherwise, if you just call an ADA consultant and ask him to help fix your website, which, that's better than not fixing your website. But then if you're sued, you would have to turn over all these documents showing that your website was not initially ADA compliant, and showing, the process of how this consultant worked with you to try to get your website to be ADA compliant. And I would much rather you not have to turn over that information. So just keep in mind of that privilege, the thought of privilege while you're thinking of all these issues. Two other quick things before I turn it over to Megan. One question we get asked all the time is, can you as a business be sued twice for the same ADA violation? And I've represented some companies that have been sued multiple times by different plaintiffs, not by the but either 2 times for these website accessibility issues that I'm talking about, or maybe once for the issue I'm talking about and once for the issue Megan is talking about. But typically what would happen is you get sued once. Let's say you agree to settle that claim, and then a few months later you get sued a second time, and you want to know, you were already sued, you successfully settled it. What happens? Can't you just dismiss the second lawsuit because it already happened? And unfortunately, there's an 11th Circuit case that says no. The 11th Circuit case found that a plaintiff, even if you've settled the exact same case before, the prior plaintiff is the only person who can enforce any rights under the settlement agreement. So that has nothing to do with a new plaintiff. So a new plaintiff who is not a party to the prior settlement agreement has his right to go to court as well. And there's no actions that you've done, any actions you've done in furtherance of settlement of the previous claim, is irrelevant to this new plaintiff. So, the takeaway from this case is it really is critical to take action as soon as possible to ensure your websites are in compliance with the ADA. So let's say you settle a case with the plaintiff and you have a year to fix your website. If you fix the website within the next month and then you get sued, then you have a great defense. Then you can tell the new plaintiff, sorry, I've already fixed my website. You don't have any sort of claim. But if you wait a year to fix your website and you just tell this new plaintiff, sorry, I've already entered into a settlement agreement and I promised to fix the website, the plaintiff will say, well, that's too bad. I don't know anything about that promise. I can't guarantee that. And then you likely will have to pay to settle this second case again. So that's really something important to keep in mind. And I have one case specifically about that from the Southern District of New York about 2 years ago, where an individual with a visual impairment sued Kroger, claiming that its website was not compatible with screen reader software. And Kroger filed a motion to dismiss saying, we actually are in the process of making our website fully compliant, and we can show you everything we've done, and there's no more barriers that exist anymore. And then the court found, you know what? The plaintiff's ADA claim was moot because Kroger's done everything they needed to do, so there was nothing else this plaintiff needed to enforce. So that really is your best strategy going forward. I have one other case here that was another successful motion to dismiss for a defendant in the Southern District of New York, where if a plaintiff just generally says, oh, your website's not compatible, but doesn't allege concrete or particularized injuries, in that case, you also could have a successful chance for a motion to dismiss if a plaintiff fails to identify which specific portions of the website he or she tried to access, or which goods or services that she was unable to purchase. And then the last thing that I just want to tell you about before I turn it over to Megan, and this is very important, is to make sure to have what's called an accessibility statement on your website that really heavily reduces your potential legal exposure for an ADA website claim. And this is something I help a ton of clients with. It takes, a few hours at the most, and it's really a good safeguard to have. All it needs to say basically is that you have taken efforts to make sure your website is accessible. You've worked with a lawyer, you've worked with a ADA consultant, and you will continue to review your website for accessibility issues. And if you have an issue, please call us and we will do our best to resolve it. That's really all it needs to say. And this came about, there's a big case out of the Eastern District of New York about 2 years ago, where a theater's policy stated that outside food was prohibited. And in response, an individual with diabetes brought suit under the ADA saying, alleging that the theater's policy of prohibiting her from bringing in outside food dissuaded her from buying a ticket because she was required to have snacks with her at all times to stabilize sudden drops in blood sugar, and thus the theater was discriminating against her. But fortunately for the theater, they had a great defense to that claim. Specifically, they had a prominently displayed accessibility policy on their website stating that the theater was accessible to all patrons and that guests with accessibility issues could email or call the theater directly. And they argued the plaintiff never called us, never asked for an exception to the policy. The court, in analyzing this case, stated that due to the accessibility's prominent display on the homepage of the website, the plaintiff must have seen the accessibility policy before she saw the policy that prohibited an individual from bringing outside food into the theater. Yet, even though she saw the policy, she never contacted the theater per the website's instructions. So she wasn't able to actually demonstrate that there was a barrier to access because she didn't take advantage of the procedure that was set forth in the accessibility policy. So I wanted to, let you know about that case just to really hammer home the point that spending an hour or two putting in accessibility on your website is really important and really can save you a whole host of headaches down the road. And with that, let me turn it now over to Megan so she can talk about this second type of accessibility issues that deal with websites.
Thanks, Jordan. So now we'll launch into that kind of second category of website accessibility claims, which has to do with the information that's available on a website about the accessible features of that hotel. So we'll talk about it in the context of hotel websites. And So hotel websites, as Jordan has described, we think of them as being subject to the ADA because they're providing information about the goods and services that the hotel offers. But unlike the website accessibility issues about, accessing being able to read the information on the website, for the hotel accessibility information available on a website, there is a specific ADA regulation on point. And it clearly outlines 5 things that public accommodation must do. So the first is that place of public accommodation must modify its policies and practices to ensure that an individual with disabilities can make reservations for accessible guest rooms in the same way that people can make reservations who are not disabled. So if somebody is looking to reserve a room on the website, and they can go on and reserve a room, but an individual trying to reserve an accessible room is not able to do that in the same way. There isn't, for example, a link to reserve an ADA room, even if there's a link to reserve every other kind of room, then that's a violation of this particular part of the regulation. Moving on to the next slide, the second piece of the regulation requires that the place of accommodation ensure that the accessible guest room is held for use by individuals with disabilities until all other guest rooms of that type have been rented. And the accessible room requested is the only one left of that type. So this essentially requires that the accessible guest room be held and not booked until all other rooms of that type have been booked. So if you have, a bunch of king rooms and you have one ADA king room, it can't be the first one that's booked, unless of course it's booked by somebody who is booking it for a disabled guest who's booking it specifically for that purpose. But it can't be the first one available to be booked. You have to kind of save it. And then if it's not booked by somebody specifically with the needs for that room, and it's the last one available, then it can be available for booking by anyone. The third section of the regulation requires that the room be reserved upon request, that the accessible guest room be able to be reserved and specifically blocked and removed from the reservation system. So there's not a possibility of double booking an accessible room. The fourth section requires that the specific accessible guest room be reserved, that there's a guarantee that that specific accessible guest room reserved is held for the reserving customer. So if a person with disabilities reserves a certain room, that specific room is being held. And that is one of the requirements laid out in the regulation. And then the fifth one, and this is the one that is really the crux of pretty much all of the lawsuits that we see in this area about accessibility information available on hotel websites. And that's that the hotel has to identify and describe the accessible features in the hotel and the guest rooms offered through its reservation service. And that information has to be in enough detail so that individuals with disabilities can assess whether the hotel or the guest rooms meets their particular accessibility needs. And again, this is where a lot of the focus of our lawsuits are. And even when the lawsuit alleges violations of the other 4 sections of the regulation, Because this fifth part is the part that's visible on the website, that becomes the biggest hurdle for overcoming in terms of settlement and in terms of defending these lawsuits, is what is the actual information that's available on the website. So these are also, and part of the reason that we see so many of these lawsuits is that these in some ways are easier logistically for plaintiffs to bring, as opposed to the more traditional brick and mortar claims of accessibility issues. And one of the reasons is because plaintiffs don't necessarily have to visit a hotel and experience a barrier in order to file a lawsuit. A lot of plaintiffs will, from the comfort of their home, visit a hotel website and be able to allege in a complaint that I didn't have the information available to me to make a decision about whether this hotel was accessible to me. And so I was deterred from being able to visit. And that's the barrier that they're able to allege. And we see a ton of these in California, and we also see a ton of these in Florida and Arizona and elsewhere. But as a member of the firm in the California practice, certainly see many of these, and lots of serial plaintiffs. So you have plaintiffs who will file hundreds of these a year, just one after another after another. So the obvious question is, so what information is enough to put on the website? And again, because while there is that regulation on point, what that regulation really means is not, there isn't a bright line rule for that. And just like in the section that Jordan discussed, we have case law to rely on, but case law can be a patchwork of different decisions in different contexts, and they certainly give us a flavor of what is required. And the Department of Justice has also given us some guidance on what is required. But the bottom line is, the more information you can provide about your accessible features, the more likely you are to be ADA compliant, and the more likely you'll be able to push back on these lawsuits. So at a minimum, we think of two categories of information that you want to have on your website. The first is information regarding whether the common areas, as well as the accessible paths to the common areas, are accessible. So if your hotel has things like a parking lot, a lobby, an entrance to the lobby, public restrooms, a pool, a restaurant or bar, fitness center or business center, or even just, door handles that you need to access in order to walk up to the front desk, as opposed to a door that opens automatically. Those are things to specifically address on your website if they're accessible, and even potentially, though we often would advise working with counsel on this, if you do have a property where some of those common areas or access to common areas are not accessible, that may also be something that you'll want to discuss with ADA counsel on how to address that on your website. It's really important that you are describing the accessible information accurately. You don't want to say that something is accessible if it's not, and risk having somebody show up, experience that barrier, and then be able to file a lawsuit, or test whether something is being described on the website and then not in fact being available. So other than common areas and access to common areas, the second category where you want to provide sufficient information regarding accessibility is on the accessible rooms. And the categories of information at a minimum that you'll want to address are the bed types, the number of beds, the type of bathroom features, specifically, is there a roll-in shower, or is there a tub with accessible seats? And things like there being non-slip grab bars around the toilet and around the tub, And there are many, many other features, accessible features of particularly the bathroom that can be described as well. And this gray area is where we get into a lot of fights and arguments with opposing counsel about what is sufficient. So again, the more information you can provide, the better. And another thing to keep in mind is, how are you providing this information? It's often the case that we, you would have maybe an accessibility feature tab or an accessibility tab on your website that would address both the accessibility in terms of what Jordan was talking about with WCAG compliance, and then also the accessible features of the hotel. And that's a place where we, often ideally will see a description of the accessible features of the hotel and the guest rooms. But the important part to remember about accessibility information about the rooms is that if there are other parts of your website that describe your hotel rooms, for example, a tab that says guest rooms, or a tab that says reserve now, and there are descriptions about the features of the hotel, that's also a really important place to repeat information about the accessible features of specific rooms. So if, let's say you have, an accessible king, a standard accessible king, and then you also have, a double queen room, and you have descriptions of all of your rooms that are available, general categories of what kinds of rooms you have. You want to make sure that those accessible rooms are also described, and that the accessible features are described on those different parts of the website. You don't want to have a situation where a guest skips the accessibility tab of your website, goes straight to the booking, tries to book an accessible room, and all of the rooms are described other than the accessibility rooms. Or the accessibility rooms are available for booking, but there's no information about the actual features of those rooms. And then the one other point is that, and I kind of touched on this, but just to make it really clear, it's really important that those rooms, that the accessibility rooms be available for booking on your website. Because if you have rooms available for booking and your accessible rooms aren't available for booking, then you run into a violation of one of the other 4 regulations that I mentioned in the beginning of this section. So moving on to the next slide, there's also a concept about the accessible rooms being dispersed among the various classes of guest room. So there's a requirement within the ADA where you have to provide people with disabilities a choice of the type of guest rooms, number of beds, and other amenities comparable to the choices you're providing other guests. So if you have many different types of rooms and you're required to have more than one accessible room, you want to kind of spread out the accessible rooms into the various types of rooms. Now, you don't have to provide every single type of room that might otherwise be available at the hotel. And one of the ways this comes up sometimes is in lawsuits alleging that there wasn't an accessible room on a given floor. And in those cases, oftentimes we see the courts pushing back and saying, you don't have to accommodate a guest's request for an accessible room on a specific floor unless you're, providing that to all other guests, but you do have to make an effort to make sure that the accessible rooms are spread out amongst the different types of rooms that are available at the hotel. And, if smaller hotels that have limited number of accessible rooms can sometimes have challenge in figuring out how to meet this dispersion requirement. And there is some guidance in kind of how you decide the priority of the dispersion of rooms. And guidance says that guest rooms should be dispersed in a specific priority. First by guest room type, next by number of beds, and finally by other amenities. So that gives us some guidance, although it's not always bright line rule that we would like to have to completely avoid litigation. So moving on to the next slide. Jordan mentioned that it's really important that you keep in mind who you might be working with in terms of third-party online travel agencies. So if your hotel has available bookings on third-party websites like Expedia, then you need to make sure you're providing the accessible information that's available on your website that's true of your hotel to those third-party providers, and making sure that they are also providing that information on their websites so that you don't wind up with a lawsuit based on a lack of information on a third-party website about the accessible features of your hotel. And that's something that, you know, plaintiffs can sue a hotel based on the information provided on a third-party website, even without directly suing that third-party provider. Now there have been, and moving on to the next slide, I'll try to get through this next kind of point rather quickly since we're getting close to our hour, but it has been an interesting development in the area of these third-party kind of online travel agency websites where federal courts have been pushing back on lawsuits, particularly those brought by serial plaintiffs, and one in particular, based on a lack of standing. And they basically have said, you know, a plaintiff is required to establish that they've sustained a direct injury as a result of an alleged wrongdoing. It's a requirement under ADA Title III. And so sometimes courts have pushed back, finding that the injury described is not sufficient to reach that standing requirement. So an example is Plaintiff Deborah Laufer, who has filed hundreds of lawsuits against hotels, alleging a violation of the ADA based on hotel websites and also third-party online reservation websites, saying that they failed to sufficiently identify the accessible features of the hotel. Okay, so this is a pretty typical website that we see in this, a lawsuit that we see in this context. Now, what happened that's interesting with Ms. Loeffler is that last year in spring, she had a lawsuit and a hotel did not respond to the lawsuit. And so she went in to get a default saying they didn't respond. I'm going to go get a judgment against them. Well, a judge in the U.S. District Court for the Northern District of New York refused to enter default judgment. And she requested that Ms. Laufer submit a brief demonstrating that she did in fact suffer an injury sufficient to meet her standing requirement. And not only that, but she asked her to do the same in 27 other lawsuits that she had filed that were virtually identical. And so here, you know, you have a court basically not just accepting a boilerplate lawsuit filed by a serial plaintiff time and time again. You have a court saying, no, you need to be more specific. You need to basically demonstrate that you've actually suffered an injury. And then a couple months later, after this order came out in New York, you had another court in Maryland dismiss a case filed by the same plaintiff. And in that one, the court basically said she didn't present any plausible facts showing that she had plans to stay at that hotel or even visit that location in the future. And here again is an example of a court kind of pushing back on these boilerplate complaints and saying you need to show something more specific to establish an injury and to establish, an actual intent to visit this hotel. And while the court, this court in Maryland, gave her an opportunity to amend the complaint, it was a dismissal without prejudice. The court did suggest that kind of general allegations of some amorphous intent to visit the hotel maybe in the future wouldn't be enough to save her claim. So although this doesn't eliminate kind of these serial plaintiffs filing lawsuits, it doesn't necessarily change the law that was in existence. It does show that there may be some impatience coming from certainly some of the federal courts on these serial plaintiffs to say, no, you really have to do more than just file a boiler complaint over and over and over again. You need to have particular facts for individual lawsuits to establish the requirements.
Someone had asked about the sample accessibility statement that I mentioned. And yeah, I was just giving, kind of general guidance about, at a minimum, your accessibility statement, should include language talking about how your website and or your property is accessible to guests and what steps you've taken to make it so accessible, and to provide relevant, contact information. I can't really give you any more information than that without knowing the particulars, of what steps you've taken. If you want to contact me and, I could spend an hour or so working with you to craft an accessibility statement, I'd be happy to do so. But there's really not just a generic accessibility statement because, I don't know what you've done. You'd have to say, oh, we talked to an ADA consultant, or we talked to a lawyer, or we've used online tools to make sure our website is accessible. So it's pretty easy, but I can't do it without knowing the particular facts of the case. And just so you see here, here's the employer defense report. If you want to subscribe to this blog, we write articles about these issues all the time, so you can see the latest developments when there's a new case that talks about website accessibility issues. We also, on our website, we have a COVID-19 task force that you can look at for COVID-19 issues. And, Megan and I do, and others in our firm do these types of webinars once a month. So here is the schedule if you want to sign up for any other webinars. And other than that, I guess we're a few minutes over now. So please, here's our contact info. Reach out to us via email with any other questions you have, and we'll be pleased to answer any questions that you have. Thank you very much for your time.